Hello everybody, welcome back. Today we are again yet under the Constitution subhead studying the chapters, and we've revised making of the Constitution, we've revised the features, we've revised the preamble, we've revised the Union and its territory, we've revised citizenship, and now we are heading towards the fundamental rights, which is a big chapter but an easy chapter but also an important chapter, and we really need to see over what all constitutes the part of our fundamental rights and how do we suffice it. See, this is chapter 7 of fundamental rights in the book Indian Polity by Lakshmikant. I am using the 5th edition book. See, fundamental rights enshrined in part 3. So part 1 was what? Union and its territory that we saw. Part 2 was what? Citizenship. And part 3 is what? It is fundamental rights, and it is article 12 to 35. 5 to 11 was under citizenship, 1 to 4 was here, and then this is 12 to 35 that we have. See, the framers of the Constitution derived the inspiration from the Constitution of USA, that is Bill of Rights. See, when we were doing chapter 3, we actually were going through the sources of the Constitution, and see, in the US Constitution that we see here, the Bill of Rights, we see fundamental rights have been a part of the sources here. So, fundamental rights, US Constitution part, it's here. So let's head back to our chapter again. See, what is happening now in fundamental rights is part 3 of the Constitution is described as the Magna Carta of India. Why? Because it contains a very long and comprehensive list of justiciable fundamental rights. Comment down what do you mean by the term justiciable and non-justiciable if you know this. Otherwise, we'll see it in this video itself. See, fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country, including the USA. So we've drawn the inspiration of putting in the fundamental rights from USA, but we have a more elaborate version than USA itself. So fundamental rights are guaranteed by the Constitution to all persons without any discrimination, uphold the equality, dignity, larger public interest and unity of the nations. They are meant for what? Promoting the ideal of political democracy, prevent establishment of an authoritarian and despotic rule in the country, and protect the liberties and freedoms of the people against the invasion by the state. How? See, they are meant for promoting the ideal of political democracy. See, if you are an individual and I've given you certain kinds of rights, that this is your right to breathe, this is your right to eat, this is your right to drink and everything. So what are you getting? You are getting an ideal of how you should be, what your rights are and how you should be acting even if you are in front of me. So what is happening? You are getting the promotion of being the ideal person that you are, and if every individual gets this promotes the ideal of political democracy. Then what? Prevent the establishment of an authoritarian despotic rule in the country. See, if I do not teach you any rights and then if I put in more of my rule over you, more of my force over you, what would happen? This would create an authoritarian and the despotic government in the country. But since you know your rights, you'll fight back that this is my right and you cannot take it away from me. So this is there, and then it protects the liberties and freedoms of the people. How you can actually fight back, so that's called freedom of yours that you can do. And then against the invasion by the state, they operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. This is very important. Why? Because this line is something that we need to understand what is happening. See, they operate as limitations on the tyranny of the executive. See, executive in our Constitution is responsible for implementing the formulations that have been done. See, now when they are implementing, they can maybe implement via the authoritarian rule that they have, or maybe by way of indulging and implementing it with amongst the public, or maybe using the public for their resources, or they can also go for the republic way to actually implement. So whatever is happening, any rule, any way that they are following, what's happening is that the tyranny of the executive that they might have put on us for implementing all the policies that have been formulated by the legislature here, we can actually check them, we can actually put them aside. Why? Because we've got our rights and we need to use it. And then what is there? And arbitrary laws of the legislature. Legislature might make law on anything, might make law on your sleeping, might make law on your drinking, might make law on your breathing. See, there are countries in this world, in this universe that you talk of, where actually the government decides when are you going to sleep, when are you going to study, which kind of haircut do you require, which kind of house should you live in, or what are the frames that should be there in your house, what are the furnitures that you should be having. So these are all there in the government, these are all there in this very world that is existing. But right now, because of our fundamental rights, we see that there are no limitations on the this fundamental rights is acting as a limitations on the tyranny of the executive, and they operate as the arbitrary laws of the legislature. They operate as the limitations on these laws. And that is why we know, no, this government is not responsible to decide how or what should be my lifestyle. So this is something that we have got it as our fundamental right, and this fundamental right acts as a limitation on the tyranny of the executive and the laws made by the legislature. Next paragraph that we have, see, the fundamental rights are named so why? Because they are guaranteed and protected by the constitution, which is a fundamental law of the land. They are fundamental also in the sense that they are most essential for the all-round development of the individual. So why is rights named fundamental? Because of the two reasons that we have here. This is very simple. Then originally constitution provided for seven fundamental rights. What were the? Equality, freedom, exploitation, religion, culture and educational rights, property, constitutional remedies. But what happens is right to property was deleted from the list of fundamental rights by the 44th Amendment Act 1978. This is the Morarji Desai government that was there. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present there are only 6 fundamental rights that we have. This is abolished and has been made as an article. See, then we have features of fundamental rights. I will quickly go through this because this is not something that we should be wasting our time on or using more than it's required. See, fundamental rights, we actually discussed it when we were doing citizenship, that some are available to the citizens and some are available to the aliens. So this can be a feature. Some available to the citizens, others available to all persons, whether citizens, foreigners, legal persons, corporates, companies, etc. See, what are they? They are not absolute but qualified. What does this mean? That the state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is decided by the court. So they are not absolute, they are qualified. When the state says, no, this shouldn't be done, or if they pose restrictions which does not hamper the freedom of the citizens of India, it actually can be passed. So they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. So this is another feature that we have. See, the third feature that we have can be, available against the arbitrary action of the states, but with a few exceptions like those against the state's action and against the action of private individuals. When the rights are available against the state's actions only are violated by the private individuals, there are no constitutional remedy but only ordinary legal remedies. If you want to understand. If you don't want to understand, you can skip this. Why? Because we have a lot of fundamental rights that we have here. See, some of them are negative in character. How? Because a lot of fundamental rights are here to push the citizens up regarding the rights that they have. But there are a lot of rights that actually put the citizens, show them that there has to be limitations on the rights, or maybe limitations on the freedom, or maybe limitation somehow. So this is negative in character. This is giving a right, but this is negative in character. How? They are putting the limitations on the authority of the state, while others are positive in character. How? That there are certain privileges on the person. See, it's just a matter of the change in words. Why? I'll tell you. See, one is pushing up the citizen by telling, you've got this right, you've got this right, you've got this right. Another is pushing down the state, saying, no, you have it, you're not allowed to do this, you're not allowed to do this, you're not allowed to do this. But once you push this down, there are certain rights that once you do this, then only you can do this. If you don't do this, this cannot happen. So this is just a exchange of words, just playing with the words. This is a jumble words thing. See, they are justiciable. That means what? That the persons can move the court for their enforcement if and when they are violated. Then they are defended and guaranteed by the Supreme Court. Hence, a aggrieved person can directly go to the Supreme Court. So this is what? This is original jurisdiction that we talk of. When we reach Supreme Court, we'll get to know it there. See, they are not sacrosanct or permanent. The Parliament can curtail or repeal them, but only by a Constitutional Amendment Act and not by an ordinary act. What is the difference? The difference is in the majorities. One is simple majority and one is special majority. Then see, they can be suspended during the operation of a national emergency, except Articles 20 and 21. What were Articles 20 and 21? It was relating to all the freedom, right to freedom. So we'll actually see why they can't be curtailed. And then we have for the 6 rights guaranteed under Article 19 can be suspended only when emergency is declared. See, this Article 19 is also right to freedom, under Article 19 we have 6 different rights. So we will see that those are also certain rights that are not suspended during the operation of a national emergency. The scope of operation is limited by Article 31A, 31B, 31C. We will see how. Then we have application to the members of the armed forces, paramilitary forces, and another can be restricted or abrogated by the Parliament. So this is also another article that is there. And then their application can be restricted while martial law is in force in any area. So this also is related to emergency, because in emergency also the power is completely into the president, and here the power is to the martial law. Then we have most of them are directly enforceable, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made by the parliament, not by state legislature, so that uniformity throughout the country is maintained. These are certain articles that is mentioned here.